how, as an advisor, can I position myself that I'm providing education versus making sure my client does not feel or seem like the advisor is providing legal advice? So let's dive into that. I think that's really, really important to kick it off.
So, in dealing with compliance and estate planning, I think that's the biggest potential red flag for advisors. Um, at the end of the day, you have to remember that unless you are an estate planner or have a JD, you are acting in a realm as a financial advisor, giving guidance and giving education. You don't want to find yourself in a situation, maybe recommending certain language in a will or trust, going over the benefits, or excuse me, you want to focus on giving the benefits and the pros and cons of the different structures out there, educating your clients so that they can make informed decisions themselves instead of being the be all of saying, this is what you need, this is what the language should read like. You're not an attorney. That's going to upset compliance departments. That's going to upset regulators potentially, and could lead to client complaints down the road. You're going to be not very happy if a couple years down the road have a client complaint coming back saying, my financial advisor told me to do X, Y, Z on a medical directive. That's you have no leg to stand on. You're not an attorney. You're not in that side. However, if you provide the information necessary on what is a medical directive or the importance of having one, that's where an advisor not just builds that client relationship, but can really build into the estate planning process where they are that educational resource where they can be the one place so that the client is not running around to three different estate attorneys trying to get an answer, or being dinged at $250 an hour to talk to an attorney for 15 minutes. You can provide those resources to the client, give some suggestions, give some best practices, but be that more educational series versus the actual estate planner. Let that process be handled by the attorneys.
Kyle, I think that's a great point, because we do get occasionally the questions where an advisor says, I know estate planning really well, and I want to be able to tell my clients, Kyle, you need to create a trust, and don't even give the client the ability to say, well, what are your options, right? So the way that we've essentially structured the platform is, one, lead with education. And I think you laid it out perfectly, is helping educate your client. What is a trust? What is a will? What are the differences? And then helping, I think, that advisor, and I think our most successful advisors that truly implements estate planning and trust and will are the ones that truly go the extra mile to make sure that the client understands what is that HIP authorization? What is the impact if something happens and you don't have that, you don't have your living will, right? And this isn't for advisors to come up with their own content. We have all that to make it easier for you as an advisor. But I just want to make sure this is really important. It should never come to a point where you as the advisor are telling your client, you should create a trust. Because if something happens, the client can come back and say, Kyle told me I need to create a trust, and I used that link that he sent me. So the link that you're providing as an advisor, again, if you've been using our platform, it's not product specific. So we've really designed our platform to make sure that we're thinking of you first in terms of liability and compliance.
Exactly. It's providing those resources so that the client can make an informed decision. That this, at the end of the day, is up to the client. I've been an advisor myself for 7 years, and I would lead with estate planning a lot, because I worked with millennial tech industry executives who had 2-3 kids, and you need to lay that out of the benefits of having this. But at the end of the day, it's up to that client to make that decision. Another great resource is getting with not just the differences between a trust and a will, but getting into kind of the players of the trust. Defining who those roles will be. What does it mean if you grant guardianship to one sibling, for example, but financial management to another, how do they interact? That type of situation where you're defining what the roles are for people so that your client can make the educated decision beyond just saying yes to an estate plan, but then how do I kind of form it? You provide those educational resources so that they can make the best decisions for themselves.
Yeah. And sorry, go ahead, Ryan.
No, I feel like education as an advisor, it's like we used to just be money managers. And now you find a dangerous advisor is really smart in taxes. They might be an EA, they might not, whatever. I think the next wave that's coming is not just about educating clients, but educating ourselves so that we can be dangerous in the conference room. You never have to give people the straight advice. But I know as an advisor, there were times when I would argue back and forth with an accountant because he was telling me why not to do a Roth conversion. I'm saying, I'm sorry, like, I know I'm not a CPA, but I know why we're doing this. I know why it's part of the plan. And you don't necessarily have to argue with attorneys, but knowing enough education allows you to make sure that they are doing the right thing. So I just think estate planning, it can be a big world. I know it's another thing to learn, but I never felt more dangerous until I started learning about taxes. And I think that's what comes with estate planning too. It's just another arrow in the quiver. And especially being educated allows you to figure out problems that clients are having. And that's all we're really doing is being problem solvers. And there's so many problems with estate planning. It creates a lot of different ways to be able to speak to the whole family. If you have young kids, you speak to the retirees. You have retirees, you get to speak to the kids. There's so many opportunities to become the family advisor. But I don't think any of that starts without education, because you're going to be scared talking about anything that you don't understand.
It's a great point, Ryan. And so where I'd like to guide this conversation, and this is just really based on feedback I've gotten a lot in the last few years. So Kyle, I as a client say, great, I went through kind of the questionnaire. I feel that the best product for me is a trust. And then the clients or the advisors that really want to provide this kind of white glove service, they say, I really want to help my client go through the process. And we've provided a checklist that we created based on advisor feedback on all the decisions you need to make and what those decisions make or mean. What would you say are some best practices, Kyle, when it comes to helping the client make some of those decisions that need to be included in the estate plan and actually start going through the process of inputting that information into the Trust and Wills platform?
Yeah, totally. Well, first of all, all of compliance, well, not all of them, a lot of compliance comes down to, like I mentioned, the CRM. It comes down to documentation. So the best practice I can, give to advisors is properly documenting all of these conversations. Now we'll get into what those can look like, but when you have these types of discussions and when these discussions kind of move outside of the realm of traditional financial planning and investment management and enter into the estate planning, the tax planning, or anything like that, you don't just want to simply just say, give the date and say, hey, I talked to client XYZ about estate planning today. That documentation is not going to serve you any purpose in the future in case somebody asks any questions. So you really want to get into what are you talking about? Providing proper, disclosures, as simple as, just a reminder, I am your financial advisor. I am educated on estate planning. However, I am not an estate planning attorney. We have services that we can offer you, but at the end of the day, those will be created outside of our firm. So proper note-taking is the biggest step you can take today when you start talking estate planning with your clients. And be detailed. Be explicit with it. Don't just say we discussed terminology. Define the terminology you went over with the client. I would highly suggest, I know Trust and Will has a great resource center, and they're very receptive to creating more information too. But having almost like a little welcome packet or informational packet that you discuss with clients that you can point to and say, this is what we went over exactly. That type of information is very key in the compliance side in case of an examination and they pull a client file, in case of a client complaint, or just compliance asking what are you doing outside of investment management. You don't just want to be very broad saying, we talk estate planning. Well, what does that mean? But if you have that proper documentation of notes and even like a little wealth estate planning information card or disclosures, all of that, that is where you can really say, this is what we talk about. And then that's great for the advisor too, to kind of keep them within the guardrails. You know, we all get into the most trouble when we start improvising, when we start kind of going off the cuff. And something with estate planning that is incredibly important. You really want to stay within your realm as the advisor. So breaking that down. So now when you get into the terminology and talking about what they should add, I'm a big believer of being open with your clients and saying, you know, if 80% of your clients that you work with are doing the trust route, your client that you're talking to today can know that. You can say the kind of general profile of those clients. You know, they kind of match you. They're in their 30s or early 40s. They have children. We are setting up trust because of XYZ, guardianship, asset protection, everything like that. Or if you're the opposite, hey, most of our clients don't need a trust. They're working in the will space, and this is why. When you provide those documented like examples of why somebody or why one would go that route over another route, you're still protecting yourself in a compliance way, but you're also greatly helping your client make that decision. Because at the end of the day, the client comes to you for information. You know, they're not, you know, doing business with you because, you know, for fun. They have financial questions that want answers, but at the end of the day, they need to make that educational decision. So if you provide all that information to it, that client is then like, okay, I do have 2 kids. It sounds like a trust might be the best thing for me. That's great to know. I'm a retiree. I don't have any heirs. I don't have any assets to give to anybody, but you know, maybe I just need a will with some quick medical, you know, that type of information. Be that resource for your clients, because outsourcing everything is nice. You don't have to, but you also don't control what's being talked about. I've seen estate plans that should be written for billionaires given to you know, tech company workers and engineers. It's not needed. You can be that resource for that client, so they're not paying $10,000 for a trust that they maybe not need. You know, you provide that information of what they should be really looking at. That client then feels, you know, very special of, I know what I'm looking for, and anything above, hey, you know, no different than the insurance agent trying to sell your clients, you know, $15 million worth of term. You're there to help those situations. And then that just builds client relationships. You have really become the quarterback, you know, the center of their financial lives that they truly go to for advice.
Mm-hmm. Kyle, I think that's great. 2 big takeaways for me is, one, document everything. And this is actually something that we'll be announcing with WealthBox, is we actually created a workflow for estate planning that helps really outline each specific step, what you're talking about in each step, to make sure that it's all documented. And then 2, I love that you talked about it's okay to say, to help educate and storytell. You know, for example, if you're in California, most families that have over 166,000, right? Like it's okay for you to be able to tell and share why clients are choosing certain products because of, you know, they have kids, they're under the age of 18. With a trust, you have more control. So I think those are really, really good takeaways. Ryan, I'll pass it back to you.
Yeah, adding into WealthBox too, I used to use WealthBox personally, and I used to use the voice feature for notes, and it does a really good job. So you know how sometimes you could be saying words and you're like, that text would never go through. Nobody would ever understand what I said. WealthBox was pretty exceptional in terms of that. So if you're popping out of a meeting and anybody's not doing that, I imagine most CRMs do. I also find you can do that on your phone. So for really good note taking for advisors, just as an aside, if you're using your phone, you use WealthBox directly. You can voice speak your notes in there. Hey, we talked about estate planning. We were talking about wills, and led it to education of why it mattered and get detail, just like Kyle was saying. And then that really helps, I think, at the end of the day. As we advisors know, just having that information is super beneficial.
And when we talk documentation, one of the things the clients I work with, there's a fear of oversharing in a client note because those are reviewed by a regulator. And I'll be the first to tell you, I've been an examiner. I've gone to offices and audited financial advisors. And when I pull a client folder and it has nothing but, one sentence notes on it, I'm going to dig a little bit deeper of what's going on. If I get a client folder that's this thick with all the documentation, it tells me you're taking it seriously. It tells me that you are truly documenting everything that's in there. I'm going to read it and make sure it's, there's no real compliance issues. But I have the firm belief of you can't really overshare on your notes. I mean, of course, be smart, just like you are in your emails. You don't want to use any of the forbidden language of guaranteeing something or going in depth of promissory, anything like that. But no regulator or compliance department is going to be, hey, why is this client file so big with your notes? They're going to be jumping up and down.
Absolutely.
It's amazing. That's when I see an advisor on that, because I've been in an office doing like OSJ delegation stuff and doing internal audits going, this is awesome. Thank you so much. We can defend this now if anything ever happens, compared to you did nothing. Why even write a note? I would rather you almost not having one, because having an insufficient one can be viewed even worse than not even doing it, because you're basically saying, I know I should do this, but I don't care enough to,
Absolutely. And let's go to a question here, and then Ryan, I'll pass it back to you, because I definitely want to shift to pre-purchasing and really help kind of outline the two differences and what that actually means. But Andrew, it's great to see you. Question from him, it says, how does it work in terms of marketing? For example, website, brochures, flyers, what we do, materials, in terms of calling ourselves one-stop shop. Do we need to worry at all about how we market, brand, etc., this from a compliance and or legal perspective?
Well, I would definitely say anything with marketing needs to be measured. You start putting yourself out there as maybe a one-stop shop. I always take it to extremes because I'm a compliance person. Think about it for yourself. If you go into a place or you send your parents to a place that's a one-stop shop for everything, and then things need to be outsourced, you're not going to be very happy with that. If I go to a mechanic and they say, don't worry, this is a one-stop shop, we can do it cheaper and all together. And then I find out that that's not the way it is. It's going all over the place, and now my bill is triple. I'm not going to be happy about that. The difference in our industry is there's legal and regulatory ramifications of that. So I wouldn't go as far as maybe suggesting in print those types of marketing materials, but saying, we do comprehensive, and that includes estate planning, review or creation or assistance in the creation. That's saying, hey, we do it, but not everybody might fit into that solution, because you might have a client show up and say, I actually have a $15 million estate, and maybe you should go talk to an estate attorney that works explicitly with the ultra high net worth. Not putting yourself, it's not a bad marketing ploy to just say we offer these services and kind of break it down, compared to saying we offer these services and it's for everybody, because it might not be.
Oh, that's a great point, Kyle. Something I've seen a lot with advisors that are actually adding, in the what we do. I've seen a lot of websites that have estate planning, and some have actually added trust and will. But I've seen that advisors go the extra mile to add, estate planning documents are not drafted in-house. We've partnered with vetted attorneys and or trust and will. So I think kind of going that extra step, that if you have a client looking at it, they know that, hey, if I go work with Kyle, Kyle's not drafting my documents. Kyle's going to help me talk about estate planning and then refer out to networks and resources that he or she has available.
Exactly.
Okay. Great.
Feels like this is just about also everybody getting set up the right way, making sure they have the right language, and then they can operate like as they always had to. where it's just like, put your disclosures here, use this correct language here, and then you start to get in the motion. So it feels like maybe a little bit of work at the front to implement, but as soon as you have these practices in place, it seems like you have this good compliance infrastructure, then you're just off to the races.
And then I'm seeing a follow-up from Andrew. I'm like, how do you show that integrated value of estate planning? Very similar to all of your other services. And that's providing, first of all, it's shown in the documentation side. Not just saying we talked, but this is what we talked about. And showing clients, materials, walking them through the process of using like a trust and will or using an outside estate attorney. That's how you provide those value and the resources show that if you are charging for this service, that you are checking off those boxes, that you're actually providing it. Because at the end of the day, regulators care the most when you start collecting fees for that service. Offering it, even if it's included in your financial planning fee, if you're not doing it pro bono and if you're charging clients for it, they want to know what you are offering. So providing that educational material, documenting that you have, providing those resources, if it's a referral into trust and will, or if it's a referral to an outsourced estate planner, if they're a little bit more complex, that's a great way to show that you're adding that value, justifying the fees associated with it.
Awesome. And moving right into, also, if anybody has any questions, like keep them coming. We'll definitely, whatever we don't get in the middle of this, we'll get at the end. So don't hesitate to keep them coming in. And with that said, I'll definitely hit your question in a second, Bonnie. Moving into pre-purchasing. This is something specific through Trust and Will, whereas when you're on the advisor dashboard, you can always share our link that clients will get 10% off for going through us. But you actually have an option to pre-purchase for your estate plans for your clients, including it in the planning fee, purchasing it for clients. I think these are all things where advisors are wondering now, I have my language down, but am I crossing the line with my actions? So Kyle, why don't you talk a little bit about what it would mean to pre-purchase and how you can do it in a compliant way?
So yes, so pre-purchasing for your clients, I think the number one question out there is, can I do this? And the answer is yes. You're providing services for the client. So you can go through and buy the estate plan, no different than if you think about like in financial planning software, you use your Right Capital, your e-money, you're paying a monthly subscription to have those financial plans created. It's not much different than paying upfront for, buying a financial plan and then delivering it to the client. You're just paying it monthly for everybody. So that has already been kind of the status quo going forward, the status quo already in regards to these types of planning documents. When you pre-purchase, you have kind of two roads to go, where you either absorb it yourself as part of the overall financial planning fee, or you charge the client on top of it. And that's going to be the biggest question you're going to have to solve for your personal business. Does it make sense to just include a pre-purchase estate plan as part of your overall financial advisory fee, or your AUM fee, or flat financial planning fee? Or if you're going to say, hey, each one cost me X, and I'm going to charge X to the client on an invoice basis for those documentations. And what you're paying for and what the client is paying for is not necessarily your service for it, but for the actual creation of those documents. So you're not really selling, for lack of a better term, estate plans. You're providing a service to the client. However, those services do cost money. And the client is now, like I said, paying you directly for estate planning services. They're paying an outside firm to actually create those documents. The last one you have is charging above and beyond a pre-purchase price, which you can do if it costs X amount of dollars and you're going to charge Y to the client to justify the expense of the document. But then you're also saying it costs us time and energy, and I'm going to charge the client on that. So in a regulated world, you're not expected to work for free. You can charge for your services. That's A-okay. Where you get is, how is that disclosed to the client? You want to be incredibly transparent in general on your pricing. But when you start adding, for lack of a better term, surcharges for additional services, clients need to know, hey, I'm paying you 1% advisory fee, and then I'm going to pay you $1,000 for this estate plan. Have that lined out. Have it be in your service agreement. Have it be an addendum to your investment advisory contract, or have a brand new, financial planning contract just associated with estate planning. You can do it multiple ways. What you need to do is just make sure that that client is never confused as to why they are paying something. They can say, I'm paying $500 for an estate plan, and I'm getting a trust out of it. You don't want to have it be, hey, what additionally am I paying for? Why isn't this included in the 1%? You can have those discussions, but once you lay it out and the client knows what they're getting into, those discussions become more talking about the pay for the service, like I said, the document creation, the payment of having an attorney on the back end or on the front end review it to get it through. As long as the client knows what they're getting into, your compliance potential issues go way down, because you remove that question, you remove that confusion. And I would be upfront and honest. We don't include it into our overall financial fee because not every client needs an estate plan. We do this for additional services for the clients that need it. No different of, hey, if you have a business you want to talk about, or real estate investments, or I saw a chat on it earlier about crypto assets, which I work with as well. If you do that, that might not be worthwhile to put into your overall financial fee if only a couple clients are going to use it. It's perfectly okay to have a separate contract that lays it all out. Just be clear, be concise, and make sure that client knows I'm paying X and I'm going to get Y in return.
That's really good points. I want to recap this really quick. So for quick context, when we first launched the advisor platform, it was all clients. It was the client paying for it with a 10% discount. As we started growing our advisor network, advisors started asking us, and Andrew, this goes back to your question, I want to be that holistic one-stop shop. And I want to include an estate plan as part of the fee that my client is charging me. This has been the most common way that advisors are pre-purchasing and implementing the estate plan as part of the fee. What we talked about, and Kyle went into a little bit more, is that we also have some advisors that say, if I am going to help my client go through the process of making the decisions, education, and you want to charge a fee for that, it is okay. But Kyle, just want to make sure I'm clear on this. It's super important for the advisor to have that in writing. What is the fee? What is covered as part of the fee? And that is also included in the contract that you talked about. Did I hear you correctly there, Kyle?
Exactly. And to be honest, even if you want to go above and beyond, you can even break it out if you go above the stated cost of the plan. If the plan costs $500 and your time costs $500, it's not a necessity to break those out, but I'm a huge fan of transparency. I like to know what I pay for. And as a regulator or an examiner, if comes and sees that, they're going to be very happy. Upfront fees is one of the biggest issues we have in the industry right now, where fees are hidden into AUM charges, expense ratios, surcharges you never see, platform fees. But if you break that out, showing your client more information is never going to be a bad thing, in my opinion. On a compliance basis.
Because I imagine regulators, compliance, everybody just wants to make sure that the client had all the information they needed to make that step forward. When we don't have notes, when we don't have anything, that's when I feel like it's in that compliance world, because whether it be advisors, insurance agents, it doesn't have the best reputation all the time. So it's important to make sure that people know exactly what they're getting into. And I think contracts, note-taking, all these little things, and let all regulators know that, okay, this is okay. because we saw that this person made their own decision. And that's what I think everybody wants to see. Obviously, there's legal things we have to fall into, but for compliance, most of the time, it just seems like, did the client know exactly what they were doing when they were doing it? And I think all these things fit in to make sure that, yes, of course it's okay, but here's how you do it to make sure it's okay.
Yes, and again, like I said, a regulator is never going to, well, not never, but you can get paid, and it's okay to charge. When we start getting excessive fees, then you might have to answer something. If Trust and Will is charging you $500 and you're charging a client $5,000 for it, you might have a situation where you have to justify the value you're adding and the time you're adding to get to that price. But to sit and say, I have to eat this as a cost of doing business, you don't have to. You can use those the resources that you have. It's part of a service model for a client. And there's clients out there, we go into the weeds of the fee discussion all the time, but there's clients out there that are willing to pay a premium for top-notch financial services. That's okay.
100%.
You're not wrong by doing that. Right. There's always somebody that's going to do it cheaper. For me in fees, there's only 3 people that should care about it. The regulators, because it needs to be transparent. Yourself, so you can run a business that's successful and not be worrying about paying the bills, and your clients, making sure they understand it and they're willing to pay it. Yeah. Everybody else, who cares?
Yeah. And this is a great question. And Bonnie, great to see you. Bonnie's like one of our biggest fans. She's super consistent, always attending these. So we appreciate you, Bonnie. Bonnie's asking, what's our duty in reviewing estate plans already in place? How do we handle that without considering into legal advice? Great question.
That is a top-notch question.
Sure is.
And for me, a lot of it comes back to education. So you as an advisor should be well-versed enough to spot potential red flags within an estate plan. Something is missing. Something just seems off. A lot of this is, the sniff test. Does it pass muster? Is there something that just, when you're reading that documentation, just seems off? And the worry about breaching into giving legal advice, you're not providing legal advice if you say, why don't you have a medical directive on this? That's not providing, you being that resource, is very important. And I think you're truly fulfilling, if you fall under the fiduciary standard, I think you reviewing that and bringing potential issues to a client is maximizing that fiduciary standard. If you're just under best interest or, suitability.
Suitable.
Yeah. Is this trust suitable for my client? Or no, why do you have 10 different add-ons if you don't need it? Why do you have like 4 levels of successor trustees to pass down $85,000 or, your children, or, have a guardianship and then maybe have a backup. You don't need to go through your entire family tree and pay an attorney an additional $2,000 to draft those documents. So You really want to look for that red flags that are out there and present it in an educational way.
And
Most
Kyle,
of our
would you go?
students have seen that.
Sorry, go ahead.
I was going to say,
go,
oh God, this is horrible.
Rock, paper,
you go. I'm going
to
be silent because I'm going to let you go.
I was going to say, would you go the extra step to say an advisor should typically not be telling the client, yes, you should update your trust, or no, you should not update your trust? Because what comes to mind is, if I'm an advisor, maybe I'm not as educated on recent changes in estate planning, whatever the case might be. And if I tell you, no, you shouldn't update your trust, but something happens, could the advisor then be held liable for something like that?
So in this industry, we kind of have a fun kind of way to frame it is anything comes across your desk, you're kind of responsible for it. But you're not expected to be an expert as well. However, you can handle that question on, Mr. and Mrs. Client. When was the last time you had your estate plan reviewed? Is this up to date and current? Just an FYI, estate planning laws and tax changes, they change year to year. You can't just, have a trust written 10 years ago and be set for life. You should have that incorporated in part of your financial plan of having that reviewed, if not annually, every couple years. So
Yeah.
there's ways to get clients thinking about it without saying, hey, you should change your trust. I would limit that type of language unless you see a glaring red flag. And again, you frame it in a way of, I see this in your trust right now. When was the last time this was reviewed? Here's my thought process on it. So instead of saying to a client, go change or update your trust, you provide that information of, I see something a little wonky here. Have you had it reviewed by an estate attorney lately? No, you haven't. Do you have an estate attorney you can go to? If not, here's some resources for you. And you can lay out of why it looks a little wonky. I'm not seeing XYZ, or, you're a very integral part of your client's financial lives. You might say, hey, I know you've gone through, a divorce, for an example, or as sad as it is, if you picked your sister as your guardian for your children and something happens to her, she gets
Absolutely.
divorced.
Yeah.
You can be that resource for that client to just kind of ping them and have them thinking about it, and then providing some information on why they should maybe get it reviewed, without saying, go update your trust, or don't update your trust, you're fine. That's the best way to do it. And your clients are going to respect you for it. They're going to say, ooh, I didn't think about that. We get engulfed in our own lives, and especially if that client has gone through a traumatic situation, they're going to love the fact that their financial advisor is thinking about them, not just on their AUM, not just on their portfolio, but their overall financial lives, and being a resource for them when they truly need it. Advisors don't earn their fees during a 10-year bull market when you throw a dart at a stock or an index and it's going to go up. They truly earn it when they're there in the hard times.
Agreed. And then moving right into, like we've been talking about the compliance side of it and all this, getting right into something that you actually helped us create was compliance resources that we have, as well as ADV language. So when you already were kind of touching over this, why don't you tell us a little bit about what you're thinking when you're creating something like this for an advisor?
So the good old ADV, you got to put everything down, and it's got to be one of those special situations where you want to be as exact as possible without being too exact. So when you update your ADV, you really want to talk about the services you are adding, whether it's estate planning, tax planning, crypto asset planning, you name it. You have to let the regulators know, and any potential client or prospective client who's pulling up your ADV, knowing what you offer. So when you write that into your ADV language, you want to break down, what are you offering? Are you charging a fee for it? Is it included in your fee? What is that fee or a fee range? You want to put that out there. The best thing to think about with an ADV, and I know it's tough to do because all of us have been in this industry probably for a long time, is remove yourself from the industry. And if you were going to go work with Ryan as the financial advisor and you pull up an ADV, what information do you want to know about Ryan to decide to do business with them?
Yeah, I'd want to know what they were charging. I'd want to know what they cost for each thing. I would want to know what they're capable of.
Yeah, and I want to know, hey, you offer, like, again, going back to holistic wealth planning or comprehensive wealth management, what does that really mean? Am I paying a surcharge or a premium for a service that might not be what I need? If you say you talk about estate planning, but does that just mean, hey, go get a trust or a will? Am I going to pay an additional fee for that service? Or is my advisor really going to help me and educate me and talk about this? So you want that ADV language to move into a situation where clients know exactly what they're getting into before they meet with you, and that a regulator knows exactly what they're getting into before, you know, you get an examination. Your ADV is one of the first things they pull. They're going to take a look at it, see what you're offering, and then they're going to see if you have policies and procedures and how you handle what you say you're offering.
Awesome. And I know there's a lot of RIAs that can just go ahead and adjust their own ADV language. And then obviously in the broker dealer world, you kind of have to listen. Would you suggest using any of this language in here as disclosures, as a separate contract that you get somebody to sign? Is there any extra layer that you feel like you have to do if you can't control your own ADV language to make sure you can still talk about estate planning even when your broker dealer won't adjust it?
So if you don't control your ADV language, for lack of a better term, you honestly don't really control your own compliance either. You have an outside compliance reviewing you. So if you're an independent broker dealer or with an independent broker dealer, you own your own business. You can run it however you want, as long as it fits within the box of that ADV or the service of that that broker dealer. You don't get to have those choices. If your broker dealer says you can't do X, Y, Z, you can't sit and say, well, I'm just going to write a disclosure on this email and I'm going to be fine. You know, that's can't really happen. So in the broker dealer world, and I've been there, I've been internal compliance, I've been branch examinations, work with your compliance department. I want to add this. How can I add it that it doesn't cause compliance headaches for me and compliance headaches for you during the course of an examination of myself?
Yeah.
So unless you fully control the compliance department of your firm, you have to ask yourself, how can I do this in a way that I'm allowed to?
I think that's super powerful too. How can I, or how do I versus can I is big difference when you're talking to compliance. Because if you say, can I, you're usually, they're not going to jump in and be like, if you do this, this, and this, and this, they're just going to be like, no, and then move on to the next person. I always found by approaching them, and for anybody who has the capability, I saw a few LPL people in here. For anybody who's able to, you can reach out. I got very friendly with my compliance department. And on a similar to making sure I wasn't sneaking by, I wasn't sly in any means. I just wanted to make sure we had the open means of communication so they didn't keep shutting me down. And I wanted things done quickly, quite frankly. So I made sure to get them to like me so that they're pushing my videos and podcasts through. But I also wanted to have an open conversation that says, hey, how do I make this happen? How can I make this compliant?
Exactly. Work with your compliance department. So, I mean, I'll echo your help at LPL. That's where I've spent the vast majority of my career between an advisor and compliance. I know a lot of people there. And what I tell consulting clients I have about dealing with a broker-dealer compliance is, number one, if they say no, get a rationale for it. Figure out what policy that you will be potentially violating to get there. Pushing back is okay. The last thing you want, though, is you have to be educated too, saying this is why I think I should do it, or this is how I want to do it. The last thing you want is them saying no, you saying yes, and it just becomes like a standoff that doesn't need to be. If an advisor comes to me and says, I really want to do this, here's why, and here is how I will do it. I'm going to listen to you more than just the advisor that says, I'm doing this.
Be more open, better understanding. Open. That makes total sense. Well, who knew that talking about compliance and estate planning would make 56 minutes go by so quickly? We had some really, really good questions. And as Ryan talked about, with Kyle's help and his firm's help, we did have 3 very specific resources to help you be more comfortable in implementing estate planning. So please reach out to us if you haven't received these yet via email. Email us at advisors@trustandwill.com.